with the facts. Something the applicant chose not to do any further with regards to what type of relief they sought. They sought a declarative. They didn't seek specific performance in prayer one then. So we needed to align everything to make sure that everything is before court, everything is properly ventilated. The facts that we rely on, which the applicant says is non-existent in that affidavit, is existent. We rely on all the facts already stated, the representation, the impossibility that they admit to say if there's a breach, it's not material, and in any event, it's impossible to agree to such a term because the President will be there. And then obviously the undue hardship has already been dealt with. It will be undignified to force the respondents to have the current President preside over the funeral of the late President.
Sorry, are you saying we must read those factors in?
Those factors are dealt with because we incorporate the factors of the answering affidavit in the counter application. We start off by saying everything that's said in the answering affidavit is applicable. The reason why the conditional counter application was filed is to bring into a conditional counter claim, which is just the prayers need to align with all the facts. So we're saying there's no agreement, but we're saying for argument's sake, if the court might find there's some sort of agreement, we need to plead in the notice of motion, in the counter application, that it is impossible to enforce that agreement that they then suppose or present to the court as the agreement. We then need to say that there's undue hardship and that specific performance under these conditions can never be granted because it is subject to the Constitution and the rights of the family. And therefore,
what are the facts for this conditional counter?
in the answering affidavit and in the affidavit itself.
So we must go and look for it in the application for
No, no, my lady,
we must go and look for facts in the answering affidavit.
No, my lady, we say what the representation is. The representation is that they would stick to AA7 and they did not. That is the representation that was
so
made.
now you say AA7
Well,
is a binding contract because they have to stick to it.
in the alternative, my lady, if this court finds there's some sort of agreement, I'm entitled to plead the alternative to say that that agreement, if it is found to be there, which we deny, is in fact there was a material misrepresentation about the facts of that agreement. And clearly there is. The parties aren't speaking about the same thing in those negotiations. Then we say further alternatively, even if this court might find that there is not a material misrepresentation, then it's impossible to enforce the agreement as pleaded by the applicant because the late President will always be there once the body is repatriated. And they say as much in the replying affidavit. They do not say he will not preside over the funeral.
Nobody seems to be upset that the President will be there, as long as he doesn't play an active role.
My lady, reading the replying affidavit of the applicant, he's going to play an active role. They're saying they don't care about this. If the body is there, it is going to happen. They say it's impossible for him not to participate in the funeral. The replying affidavit.
But a concession was made earlier in submission that the candidate insists that he should preside, if I understood Mr. Counsel for the applicant correctly.
No, he should not preside. That's paragraph 7.6, which was clearly denied in the answering affidavit. Even paragraph 7.6 in the founding affidavit doesn't say what was submitted to the court. It's the paragraph 7.6 of the founding affidavit, I think, what my lord is referring to.
My lord, what I intended to convey was that there may be a difference of interpretation. What does the word preside mean? And what we say is that if you look at what the President would do, he would be present when the military honours take place. He will be present when the funeral service is that's presided over by Bishop Banda, when that takes place, because he will receive the foreign heads of state. If that means he will preside, yes, then he presides. So it's an interpretation issue. They understand what they contend is that he shouldn't be there and he shouldn't use the word preside. What we say is he will do what FAA 7 says. That's what he will do. Nothing more, nothing less. May it please you, Lord.
As the court pleases, I've made the submissions on the conditional counterclaim. I don't know if there's any questions on that point. With regards to the striking out application of the applicants against certain portions of the answering affidavit, I'll be very quick. I do submit that at the very least, it's not really necessary to decide if it's vexatious or scandalous or irrelevant. They haven't showed any prejudice in those matter being before court. With all due respect, it also doesn't really make sense because in that application they're blowing hot and cold. They seek to take out certain portions, but there are a lot of other portions that set out the facts in any event and deals with how the late president was treated by the current president. So in any event, the striking out application doesn't make a lot of sense because it still leaves in most of the evidence.
But those are facts that they could answer to.
My lady directed for answer to all the facts with all due respect. So when we say he was refused medical treatment and we attach a letter to the paper showing that he could not leave Zambia, they could say then obviously this is the reason for that. When he was refused to go to church, it's a factual event which they can answer to. Was he refused to go to church? If he was refused, what's the reason for that? Did they stop him from jogging? Is it true? And what's the reason for that? Did they open several criminal cases against his family? Is it true? Is there good reason for that? All of that they can answer to. There's no reason not to answer to it. The reason why it's in the application is not because it's irrelevant. It's to give context to this court in interpreting what the situation is between the parties and understanding the position of the respondent and why they feel so strongly about the material term of the current president not having to do anything with the burial. So I would submit the striking application should be dismissed with cost, the same cost as what I'll argue, or it should be cost in the court. With regards to the respondent's striking out application, there are certain passages in the replying affidavit that wants to, and stated as a fact, which is all hearsay, that the president wanted to be buried in Zambia. And I've listed those paragraphs. There's no evidence showing that he wanted to be buried in Zambia, and they cannot make that submission to the court, and this court can never find such a fact exists. Wherefore, those parts in our striking application is all hearsay and irrelevant and should be struck from the replying affidavit with all due respect. The last issue, which I will not belabor, I'll just submit, and the submission is already made in my heads of argument with regards to the ex parte order that was made by this court by the variation of the original court order in the conduct of the attorney for the applicant. The papers make it clear that she was aware of certain facts which she did not convey to the court. And under those circumstances, that instance needs to be referred to the LPC for further investigation. It should not transpire that any officer of this court, as court pleases, my lord?
Has that been done?
It is in our...
Complaint been,
no complaint has formally yet been lodged. We are a bit busy with this, but I take my lord's word. As the court pleases, like I say, I'm not going to take it further than what is said in the heads of argument. Then with regards to cost, we deal with cost also quite comprehensively in our heads of argument and set out the reasons why costs should be awarded on an attorney-client scale in favour of the respondents. If it's not on an attorney-client scale, I would submit that cost on a scale C would be appropriate, including obviously a cost of the employment of two counsel. The reason being the very serious nature of the application, that the respondent was forced to abandon a burial that was already planned, money already spent. It caused great embarrassment to the respondent and the family to having to cancel that burial on a very, very short notice. The original application, they say in the urgent application that they got notice on the 18th of June that the body will not be repatriated back to Zambia. That's correct. Then they ought to have brought it already on the 20th and not waited till the 25th on the day of the burial to bring such an application. It's an abuse of process and caused great distress, especially to the widow of the late president, and embarrassment because everybody was already sitting and present at the burial that was arranged for the 25th of June. Further than that, we see, and I submit, that the founding affidavit does not support the relief that the applicant's contending for. It's seeking a declarator, but in fact it seems to be more relying on an agreement. They're not pleading specific performance at all. They're not seeking really specific performance in the notice of motion at all. They would never be entitled to a declarator that they're seeking because the case is really about an agreement. A declarator is something else with different requirements. That's the court pleases, my lord. That's all for the respondents. I just want to...
Given regards to the nature of this matter, parties sit down, try to reach an equitable solution.
My lord.
I'm not yet done. There are the work costs that were incurred by the respondents involving funeral assault. Wouldn't it be appropriate that the court should make an order that each party pays on this?
Yeah, my lord, it's a very novel application. I understand what my lord's conveying, that it might be an option for this court under the circumstances dealing with the burial rights, and that there's not really, it seems, pertinent case law on this point yet. It is probably a little bit novel. I can't take it further than that, except to say the respondent should not be out of pocket for trying to...
Somehow, it might be there's a concession by the government that they should get benefits, should get a house, and so on.
Well, my lord, unfortunately...
The pension going forward.
My lord, unfortunately, I'm not in a position to say what's happening in Zambia and why, or anything at all with regard to, let's call it, undertakings and whether they'll be kept or not kept, and I'm not going to venture into those grounds.
No, but my main question is, would it be appropriate for this court to make such an order?
About benefits, then?
No, that
Well,
each party should be liable for its own costs in this application.
my lord, I don't think it would be appropriate. I don't think the respondent needs to be out of pocket, with all due respect, but I understand that it's a novel point.
Christian, going to 15
minutes, my lord. Firstly, I must just start with a correction. The Kutuane matter, I submitted or stated that matter dealt with a civil law marriage. It's not correct. This is a pre-constitutional matter. It was heard on the 14th of August 1992. So he deals with a customary law marriage, but it was argued on the basis of the common law foot, Van Leeuwen and those authorities. And it's in that context that the judge made those remarks. There's another matter that I just need to also draw your attention to. It's the matter of MT and MC, MT versus MC and Faith Funeral Home. We will upload the reference on case lines. It's the case number. It's a decision by Adams J, Mr. Justice Adams in the South Gauteng High Court. And in that matter also, he came to the conclusion that where there are multiple competing and practical considerations or multiple competing claims, these cannot be ignored and cannot be governed and resolved strictly on the basis of the principles according to the granting of interdicts. The court is obliged to adopt a practical common sense approach. So what the court here did was exactly what the court did in the Tsambo and the matter that I referred to.
Which case would that be?
It is this case of...
I know I went to it, but I can't remember.
It's MT and MC versus Faith Funeral Home. My lord, I don't know if it is in the bundle. It's not in this bundle. It's either referred to by my learned friend or it was referred to in the matters that were quoted. So we will upload a copy of this decision. But it certainly also lends support to a more equitable approach or more common sense approach, and especially in this type of matter. Firstly, starting with the submission, which I found rather extraordinary, that the late President was an ordinary Zambian. That is simply preposterous. But that argument it's grounded on the provisions of the Benefits Act. And the applicant, through the mouth of the Attorney General, says the Benefit Act is clear that the benefits are just suspended for so long as you engage in active politics. Upon his death, that impediment or the reason for the suspension falls away and the benefits become payable. One of the benefits is funeral costs. And what the Attorney General says is this is the way the Act should be interpreted, which is in the realm of, obviously, your Lordships and my lady can read the Act. The Attorney General confirms that a sensible interpretation is the interpretation that the applicant attaches to it.
Are we getting an assurance that PESAL now in Zambia is running in favor of the widow?
It will, it must. That's what the Act says. She will get a house, I think she gets a car, children get benefits, those will follow. It's in the papers. Then,
the concession really as to how they actually calculate some
yeah,
concession that is made.
based on the papers, my lord, yes. The first point, the question of the wishes of the deceased, what my learned friend did, there's a fancy word to it. If you look at the line and your eye jumps to another point, there's an explanation for that. Your Lordship, or the court referred, my learned friend, to what is stated as far as the wishes of the deceased are concerned, and that is in paragraph 7.6. The family objected that the late President stated his wishes. My learned friend said, no, but that's denied. And then he referred the court to paragraph, the answering affidavit, paragraph 19.1 on 044. But if you look at 044, paragraph 19.1, no, sorry, my learned friend referred to paragraph 24. He said, it is denied that the President would preside over a state funeral. It was proposed that the current President only be allowed to receive funding. So his answer to was that, were those the wishes of the President? He said, no, look at what is stated in 24.2. But that deals with an entirely different paragraph. That deals with 7.10. We are busy dealing with 7.6. 7.6 sets out the wishes of the family, or the late President, and that is dealt with in 19.1 on 044. And there the respondent says, the proposed conditions of my family are stated herein. From the listed conditions, it is clear that the family would not agree to the current President playing any role in the burial of the late President Lungu. So they don't take issue with the fact that, on their version, those were the wishes of the late President. So the submission that there is no evidence as to his wishes is wrong. It is as we say in the supplementary founding affidavit, paragraph 7.6. It's not denied. Then the second point that my learned friend forcefully argued, there was no agreement. What he never referred to is what is in paragraph 9.5. 9.5 of the supplementary founding affidavit on page K24. 9.5 reads, the seventh respondent, Mr. Zulu, set out the compromise agreement that was reached. My learned friend didn't deal with that because he can't. On the family's own version, there was an agreement. So they can't turn around and argue and make submissions contrary to what is common cause on the papers. Mr. Zulu set out Number one, it will be repatriated. I'm not going to go through. So my submission is simply that contention that there was no agreement is untenable. That takes me to the Plascon-Evans rule. That was at times, see, it's one of the deck chairs that just went my life. The Plascon-Evans rule, yes, that rule does apply, but the court also is entitled to adopt a robust approach. A line of cases of Nantini versus Mull, and especially in circumstances such as the present, where we sit, the court has to deal on an urgent basis. It needs to adopt that common sense approach advocated in those line of cases that go back many, many decades, and tells the court how it should deal with if there are disputes, or fact which I contend there are not. Then the question of the defective notice of motion, it came as a bit of a surprise to me. What the applicant, how the notice of motion is structured, is a declarator declaring the right of the applicant to have the body repatriated, coupled with an interdict that the sheriff would be entitled to cause the transport of the body, and that declaratory relief is squarely grounded on the clear right that the applicant says exists. So the contention that the notice of motion is somewhat flawed, somehow flawed, I submit can't hold any water. Then the question or the issues with the counter application, the impossibility and the hardship, those are defences clearly. You don't raise a counter application, you don't bring a counter application to put that before a court. You simply argue, you put the facts and you argue on the facts. If the agreement can't be implemented, if it's impossible, there's no counterclaim that you need to bring. It's when you deal with misrepresentation and the right to resile from the contract, that clearly is on a different plane. There you would need a counter application. I must correct myself, not even. There is authority to the effect that you can raise that as a defense as well, the right to cancel. So it all turns on the merits. In other words, if there are there prospects of success, we say there are no, because the facts are missing, and in any event there is no satisfactory explanation. The last issue, the question of striking out that the respondents seek insofar as the allegations in the counter in the reply are concerned. I'm not going to read through those, my lord and my lady. If you read through the allegations that the applicant seek to strike, they are clearly not hearsay. For example, where the Attorney General says, based on the evidence, that's one example that comes to mind. Based on the evidence, it is clear that a certain conclusion must follow. They want that strike, they said it's hearsay. That's clearly not hearsay by any stretch of the imagination. That leaves me with costs. My lord, my ladies, the court indicated that an equitable approach, costs always has that component, maybe not to make an order of costs as to costs. We will obviously not object if you exercise your discretion in that manner, but what we say is ordinarily we would be entitled to costs, and we would also be entitled to the costs of the urgent application. That was because the applicant found out on the 23rd that the funeral will take place on the 25th. It had no choice but to rush to court to interdict the proceedings, and we say that if there's a cost order, the applicant should also be granted the cost of that proceeding or that process.
For the conduct of the applicant in approaching this court on an ex parte basis, as an effect, the matter that was already proposed.
Yes.
Isn't that something that we need to look at?
My lord, what happened there?
Decision of court.
Yes. What happened there is that there was some debate between the parties as to the interpretation of the court order, and the applicant invited the respondent to state its interpretation of the order, which was...
Made by agreement, I think we should keep that in mind.
Yes, yes. What the applicant said is that our understanding, taking into consideration the context of that order, is that the body will stay with the undertaker and you can't remove it. And the reason why that debate ensued was because the applicant obtained information that there may be an attempt to move the body. And when the respondent then said, no, we're not in agreement, that's not how the order should be interpreted, the applicant approached the court on the basis that the order was granted in the common, or on the common understanding that the body will not be moved. Because it will not make sense if these proceedings would proceed and in the interim the respondents can simply move the body, bury it to whatever this proceedings set out to prevent. Now the respondents complain and say no, but the attorney misled the court. That is simply presumptuous, and if they proceed with a complaint, they're obviously welcome to do so. That complaint will be dealt with, no doubt, accordingly. So, my lord, you may consider the ex parte application. If I'm correct, we don't see costs as far as that is concerned. My learned junior can check. I don't think. Yes. So those costs shouldn't play a role, and you can take it into account, certainly. My pleasure.
Thank you very much. The sample submissions made by our council. We hope it will make our council, this difficult council, it's easier to deal with. We are also alive. There is an urgent matter that is that judgment should be delivered quickly. The undertaking that this court can make is that will ensure that judgment is delivered not later than Friday. It may be tomorrow, but not later than Friday.
May I please?
And those ladies, court agents.